Well, Henshaw here again, Constitutional Kook headquarters, and another update on ongoing current events. And I've talked rather a bit about, the situation with mortgage banksters, and student loans and what have you. And the exciting news about this, now that we're getting into here, is another issue I've been working on of the California District Courts. Not federal district court, California District Court. That's a recognized constitutional common law court. And there's one of those required in every county and every state admitted into this union, including your jurisdiction, wherever you are. It may not be as clear as it happily is in California with the original Constitution of 1849, where they set this up and we have district judges, and the jurisdiction was well defined as the judicial power of the state of California. And note by contrast today that the current Constitution of 1879, allegedly in effect, doesn't even mention the judicial power of California anywhere in it. And it doesn't need to, people, because what happened with the non-existent 14th War Amendment is that there was created a subordinate political society, for want of a better word, that didn't have any rights that the de facto National Socialist government was bound to respect, and sure as hell didn't have any need for judicial courts now, did they? Not to mention the right to trial by jury according to the course of the common law. They couldn't come right out and say that, in 1868, and indeed a lot of what was in the amendment that was ratified, quote unquote, the people that ratified it didn't have a clue what they were doing. That alone defeats the amendment. And as you'll learn from sending me information from my constitutional defense document packets, modestly priced, you'll run a lot of issues like this that, they say the truth will set you free. And that's true, I can tell you. It is. And all this stuff goes back, most of it goes back to the war between the states. Some of it goes back even earlier than that. And in fact, it may have been sold out by the Treaty of Paris in 1783, a video for another day. But you learn about stuff like this and present these issues. And even in their corrupt courts, this can have an effect. But if we get into the California District Court or the equivalent thereof, where we have status and standing and they don't. That's the beauty of the people. We had rights to, life, liberty, and pursuit of happiness. The original intent of the framers of the Constitution recognized it. The only nation ever set up where that's happened. The human life had value. We had real lives. We had real property. And it's completely reversed. The 14th Amendment did that. And by the way, one of the secret intents of that amendment, quote unquote, was to make citizens out of corporations. And that's the only citizenship they recognize today. Corporations, don't exist. They certainly don't have any inalienable rights secured by the Constitution. And yet that's the only citizenship recognized today in any of these courts, except our California district courts that do come under the original intent. And in California, wouldn't you know, I happily have a document from the Secretary of State here in Sacramento admitting, pursuant to a FOIA request, there's no evidence that the Constitution of 1849 was repealed. That's true. And it's true where you are, assuming arguendo that your state was admitted prior to 1861. And the last such state of that type would be Minnesota in February of 1859. The ones that were admitted after were all admitted pursuant to the war powers of Congress. That's why the yellow fringe is on the flag when you walk into any of their goddamn courts. It's a military tribunal, and that's the name of that tune. But they can't compel us into that jurisdiction. We haven't made any voluntary, knowing, and intelligent waiver of rights. Certainly not the right to trial by jury according to the course of the common law that's secured to inhabitants of territories, for crying out loud, by the Northwest Ordinance of 1787, yet nowhere in sight today in any of what fraudulently purport to be states admitted into this union. Yeah, it's a big deal, but comparatively simple. And if we ever get to a jury, and at this stage of life, I'm not going to see one, and I knew a while back I was never going to see one in any setting. They can't afford to have that happen. But as a result, I won my Oakland case of, getting a black victim out there charged with 14 felonies. We got a time served plea deal, and they couldn't allow it to go to trial with both he, his mom, and me testifying, and me as an expert witness on the Constitution. We would have woke the jury up in a hurry. That can't happen. My South Carolina case, felony case, I got transported across the country, 2 months in federal military aircraft. Get there, in the first 30 seconds, I shut them up. First appearance. Well, if I had that's $1 million video, which they claim not to have made in the court of record. But the charge was a felony, practicing law without a license, and I'm standing there manacled hand and foot in a red jail suit. I laughed. And I said, the problem with that is I don't practice law. I get it right the first time. And then they went on and told me they had to be sure that I had the confidence to represent myself. And I threw up my hands, or I would have done that if I could have. And I said, oh, here we go, bark that up, for better be California. And I not so gently reminded them that the Supreme Court said that the Bill of Rights doesn't apply to the states. And think about this, people, and you see this every day. You don't realize, instinctively you do, but think about what's going on here. In just about every setting that we engage, government officials and positions of honor, profit, and trust in government, there's an underlying presumption of incompetence of us. Now think about that, especially in their courts. We go in there, we're incompetent from day one. Well, among other things, how in the world could we be competent to form the criminal intent to commit the crime, aka these days public offense, if we're not confident? Silly on its face. But more seriously, the relationship between us and government, particularly lawful de jure jus sanguinis state citizens, principal and agent. We are ordained and established this Constitution to secure the blessings of liberty to ourselves and our posterity. If we're not competent now, how in the hell were our ancestors competent to have done all of that? Think about it. What changed? And you send me an email, uwinnincourt@gmail.com. You'll get information back on my constitutional defense document packets, and you'll learn a lot about exactly how that happened and what we can do about it. And there's a lot, especially with mortgage banksters. And by the way, like they say in Langley, Virginia, CIA, black is white. The corporations are the ones who don't exist. We do. They think, and I mean, just every agent in government, whether they know it or not, operate on the principle, especially with state citizens, that we are undocumented enemy aliens. And if you don't think that's true, idiot Biden just sicked Merrick Garland, the U.S. Attorney General. Thank God he didn't get appointed to the 9 parts on people that had children in school that were opposed to the critical race theory, to go after them as domestic terrorists. That's how bad this has gotten. And this stupid ass government takes this seriously. And here, all we're doing is trying to invoke rights secured by the Constitution. Now, tell me how in this day and age that could be confused with domestic terrorism. I'd love to hear it. If anybody has a clue about that, because I sure don't. Well, I've gotten a little astray here, but you get the point. That it's the mortgage lender that doesn't exist, and we can prove it. It's stunning. You read what I have in my constitutional defense document packets. They're the ones that don't exist, number one. Number two, when you entered into whatever agreement it was you entered into, they did not tell you all of the terms and conditions. At common law, that's an affirmative defense that defeats any otherwise allegedly valid contract. And they certainly didn't tell you that they were the ones able to create money out of debt with paper money, undefined dollars, and yet they want to take 20, 30 or more years of your property in the form of your time and labor to pay them back. How the hell does that possibly work? And how in the world can they possibly go before a jury, assuming that they had status to do it, and try to defend against the arguments that we can make? Is so logical and common sense, and juries are going to get this. Even if law school graduates don't, even if state bar association attorneys don't, even if black robe bastards don't, juries will, because we're going to tell them and explain it to them. And with my materials, by the way, the whole package, you get at the moment almost 600 jury instructions to help do just that. It may be up to 700 before the year is over. And with my packets, by the way, among other things, you get the complimentary copies of new documents for a year from the time you got them, and updated documents, complimentary phone consultations, a lot of TLC via email, and even a complimentary Zoom appearance at a contested hearing. So I have your back here. Now you have some work to do. You have to read and study my documents. It won't take you nearly the 10,000 hours I'd put in those musty old law books in UC Berkeley and Hastings College back in the day when I could get into them. Luckily for me, that was the best way for me to learn. And it isn't just memorizing things, people. It's far from it. And when you start to get enough better, where you realize how some of the parts go together, I didn't get it overnight either. When I did, especially with there being no states, that's a stunner. But now you relate everything in that way, and it all makes sense, and it will make sense to a jury we're never going to see. That's how good it is. So that said, and one of the research materials I use, by the way, I can show you here for the purposes of this video, and that's my Black's Fourth Law Dictionary, almost 1,800 pages. And I conveniently just happen to have a copy of this available for the first one that calls in and requests information on my document packets. Well, let me hold it up here so you can see a little bit. And this is 1968, and it goes back into an era where a lot of the definitions that are in this version aren't there anymore. And things have changed over the course of time, especially since that bastard Roosevelt got in office in the 1930s, the New Deal. They didn't bother to tell us it was a deck full of 54 jokers. But that said, my Black Fourth is available at $175 plus about $10 for shipping. And it's an excellent research tool to have, and you can go in and look up terms and conditions and see what they think they mean. Because the legal lingo is a lot different than it is on the street. And that's one reason that we should have a right to effective assistance of counsel, so that we could make arguments like this in their corrupt courts. Not only do we not have it, the state bar association attorneys, aka unregistered foreign agents, will not raise any of these issues, even if we give them all the paperwork and order them to do it. It's an irreconcilable conflict of interest there, because they're protecting what I call their malignant, malevolent monopoly on the practice of law. And every one of the issues I advocate challenges it, and it will do so successfully. They don't want to hear it. Now, the good news about that for us is that the 9 old farts in Washington, D.C. have said in a case called Argo Singer v. Hamlin Sheriff, 407 U.S. 25, page 40, that each judge knows at the start of a misdemeanor trial, let alone felony, no jail time can be imposed, though local law permits it, when the accused was not represented at trial. And we can not only show that we weren't represented, we can now prove with my document packets that we have not made a voluntary, knowing, and intelligent waiver of counsel. That's the Achilles heel of the entire system. It's the only right they think we have. And we can prove that we did, and we did everything we could do. In fact, one of my documents that you'll get with my packets is called Conditional Acceptance of Counsel. And we say, fine, you will accept your counsel if the counsel will do what it is we wish them to do. And you get all the documents, and you have to do some light editing on it, but very light. You give them to counsel and say, file these documents, set up a hearing, and get this case over with. I've yet to see one that will do it. If that's the case, that's per se ineffective assistance of counsel. Given the fact that we can say it with attitude and with authority. And when I say that, by the way, what you get with my document package is a 41-page motion to dismiss and an 83-page brief on admission of new states. None of it has ever been opposed, including my bill of particulars, and that beats him not having responded to that document, because they're saying to you, we don't have to tell you what the jurisdiction and venue is. We don't have to tell you the rules of the game, the elements of the crimes you supposedly committed, aka commercial crimes these days, and we don't even have to identify an injured party. And that's a real problem, because even in their corrupt system, we have the right to confrontation and cross-examination. And you're going to learn a whole lot about who we're going to be serving a subpoena on if it comes to that, for that purpose. So that said, send me an email, uwinnincourt@gmail.com, for information about that and about my Black Sport Law Dictionary. And we can go from there and beat these mortgage bankers, beat student loans. And especially if we get in the California District Court or the equivalent in your jurisdiction, that's a constitutional common law court that's required to be there. No courts like that, no states. No states, no government. Simple. That said, remember to subscribe, like the videos, tell your friends, get the word out. If we all start working together here and cut out this divide and conquer BS they've been doing for way too long, Americans, Asians, and Africans all, the sooner we do that, the quicker we get them off our backs. Thank you.